A common law lawyer based in the southwest region of Cameroon, barrister Anyang Lewis, last week sued Cameroon's Minister of Justice, filing a motion against the revered minister under the grounds that the Minister of Justice, who is supposed to be a respecter of law and preach the respect of law, is not respecting the laws of the nation as far as organizing the pupillage and bar exam is concerned. According to Barrister Lewis in his motion, which was filed last week against Cameroon's Minister of Justice, Laurent Esso, he stated that the minister failed to respect the text regulating the organization of the bar entrance examination into the aptitude and pupillage exam, citing the text from the decree that was signed in 1991, in July 1991, 305, which stated that the minister has the prerogative in organizing the bar exam, the aptitude and the pupillage exam. It has been decades since the last bar exam was organized in Cameroon, giving way for so many aspiring candidates to become lawyers and to be called into bar. As it stands now, Cameroon does not have a law school. There is no law school in Cameroon. And so, if someone aspires to be a lawyer in Cameroon, that person has to go to the University of Buea or any other university that has a department of law, and you have to graduate with your first degree in law, sign into a chambers pending the organization of the bar exam. If that is not called, you will still have to wait at the chambers and keep working at the chambers until the year that the bar exam is called for you to come and write. And when you write, you have to pass first the aptitude test, then second, you pass the pupillage test before you are called into the bar to serve as a legal mind within Cameroon. And also, for you to bypass this process, therefore, you have to pay a lot of money, which demands that you go to a law school, a country or a nation that has a law school. Over time, Cameroonians have gone to Nigeria or to the Gambia, Rwanda, which is now having a problem because some students or those who are aspiring to become lawyers are having difficulties in Rwanda Law School under the context that for them to be admitted, they must come with their certificate to show that they have an LLB in law at the level of the university. And also in Nigeria, it's kind of very complicated as many Cameroonians are having difficulties these days to be enrolled in the law school in Nigeria. And in the Gambia intake in their law school is maximum 100 per year. And that 100 includes their own nationals, to be fair, which means that their own nationals and including other nationals, which to tell you is not only Cameroonians that goes to the Gambia. So the intake is quite limited. And if you look at the numbers of students that have been graduated under the Faculty of Law in the University of Buea, it is quite alarming as each year close to hundreds of students are being graduating from the Faculty of Law in the Department of Law in the University of Buea and other universities across Cameroon. To be more precise, you can have about 1,000 or 2 plus across Cameroon. And if these numbers are to go to a law school in the Gambia, it means that only few will survive. But with that in mind, for close to 10 years now, many who want to become lawyers are having these difficulties because not all families have the money to send their children to law school. With that is why Barrister Anyang Lewis sued Cameroon's Minister of Justice and called for the law or the court to order the minister to organize the bar exam. But the question now that we are asking, will he succeed in his quest for justice for those who are aspiring to become lawyers? Will he succeed? Cameroon's Minister of Territorial Administration, Paul Atanganji, has always been truncating or championing that Cameroon is a state of law. According to Minister Paul Atanganji, the law is a law and must be respected by all, and that no one is supposed to be above the law, and the law must take its course. With Barrister Anyang Lewis citing the case of the decree number 91 of 305 July 1991, can the law be the law? This is House of Commons with me, Tah Mai Javis. You're welcome back from that transition. If you are watching us, you're watching House of Commons here at My Media Prime Television, Cameroon's commercial capital, Douala Fengu Drombange. Here in the studio, we have Nick Anu, who is a member of the civil society. Nick, happy Sunday and thanks for joining us.
Happy Sunday, Mr. Tah Mai Javis. Thanks for having me also here. Happy Sunday to fellow listeners of My Media Prime all over the globe. Thank you.
Thank you very much. We await the arrival of barrister Anyang Lewis, who will soon be here, and also we await the arrival of Mr. Desmond, who will soon be here. But in 2006, November 2006, barrister Ntoko wrote a lengthy piece. Barrister Ntoko, Justice Ebain Ntoko, president of the FACO Lawyers Association, wrote a lengthy piece as far as the bar exam and the non-respect of the rule of law is concerned. And I read, based on what Barrister Ntoko wrote, that was published in Upstation Club. He said that I write to express my disenchantment with the subsistent and stagnating state of the bar and the astonishing levity and nonchalance of the authorities called upon by regulation in force to conduct the bar entrance examination. Thus, the Minister of Justice and Keeper of the Seal and the President of the Bar Council in Cameroon, aspirants to the legal profession are mandatory required by implication of the law organizing practice at the bar, law number 09/059 of 19 December 1990, to affiliate / attach with a law firm after their LLB program for the purpose of being called into training at the bar. Meanwhile, the decree number 91/3052 of 4th of July 1994, organizing the aptitude examination into pupillage at the bar, makes the following provision. Article 1. The aptitude exam into the pupillage shall be written in the month of December every year. I take that again. Article 1 of the decree number 91/3052 of 4th of July 1991, organizing the aptitude exam into pupillage at the bar, makes the following provision. Article 1 states that the aptitude exam into pupillage shall be written in the month of December every year. Article 2, Article 2, an order of the Minister of Justice shall fix the condition of organizing, date, place, and exams, as well as the list of candidates. Article 13, the Minister of Justice, Keeper of the Seal, and the President of the Bar Council, Batonyume in bracket, are, as they are concerned, charged with the application of the present decree. Article 13, SOPRA, invests the Minister of Justice and the President of the Bar Council with the responsibility of ensuring, inter alia, that the bar entrance examination is conducted every year and in the month of December. In fact, to facilitate the organization of the said entrance examination, Article 12 sub 1 of the decree aforesaid further provide that the fees for the organization of the said exams shall be included into the budget of the Ministry of Justice. Unfortunately, in persistent disregard of the decree, the entrance examination into the pupillage at the bar has not been written for 6 solid consecutive years now. This is continuously violation of the decree aforesaid and complete abnegation of the rule of law. The rule of law in every community presupposes the supremacy of regular as opposed to the arbitrary power and the clarion adherence to prescription, directive and regulations and laws. The rule of law further ordains that persons placed whereby the election or appointed in position of authority and invested with competence with competence to officiate acts on matter that affect economic, professional, and political human rights / interests of the people must discharge such competence judiciously and consciously. In the event that such person in authority fail, neglect, or omit to do so invested, they should be visited with some conceive or persuasive regulatory check mark to ensure not only their pictorial adherence to the rule, but also to foster subsequent fragile breaches. Such safeguards and check marks of the rule of law are sine qua non to every modern democracy. Amazing in Cameroon, that is Barrister Toko, who wrote in 2006. Amazing in Cameroon, in the case that this bar is far from being so, the aforementioned presidential decree regulating the aptitude exam into the pupillage and the bar is being abused, disrespected, violated, ignored, and thrown into terrible disrepute and neglect with absolute impunity to what now seems to be a conspirational abrogation by silence of all authorities with competency to checkmark violation. More disenchantment, more disheartening is the realization that even the Parliament (National Assembly) that plays a role of monitoring governmental action so as to formulate adequate and relevant question before the Minister of State at its question time session in the Parliament seems either to docile oblivion of the nonchalant towards this manifest in shall. It is intriguing why why the Parliament has never questioned the Minister of Justice, why he persistently failed to cause the bar entrance exam to be written as stated by the law and the entrance examination. Nursing, engineering, agronomy, and other professional early school continue to be organized each year. What bond does the regime have to pick with the legal profession? Why stifle the growth of the bar and occasion of frustration to hundreds of aspirants languishing in the different law firms all over the country, anticipating in fulfilling to enter the bar profession? Why turn the dreams of ambitious jurists into nightmare or despondency, frustration, and disappointment? It is true that the inner logic of any tyrannical regime is to foster the growth or emergence of real or potential challengers of the status quo so as to prepare itself in governance. This explains why elite professional schools bred only Confucianists to the system, and with this genre, the tyrannical regime will be comfortable because it can control their vote holding and thought of process. However, with the situation of the bar, such a regime will be wary of the caliber of free thinking that breeds, since it cannot control the lawyer's training or material content of instructions and supervisions after the LLB, lawyers being the intellectual, ideological lubricant to any organized movement positive for change. This will seem profile some logic as to why the bar is being muzzled and stifled with impunity. But is Cameroon a tyranny or a democracy? Question mark. Certainly, we cannot pass for the former, or could there yet be a middle ground? Let the bar be open, let the rule of law prevail and be respected, so as to gestation these predictions as our predictions will always propel us to. Justice Ebain Toko, President of the Law Association. That was what Justice Ebain Toko wrote in 2006. That was published about the bar exam. We'll take on this break, and when we come back, we'll set the ball rolling. I repeat again, Cameroon's Minister of Territorial Administration, Paul Atanganji, has always pointed out that the law is the law. No one is supposed to be above the law, and no one is supposed to be below the law. Minister Paul Atanganji, well respected, always stands for the fact that Cameroon is a state of law. With this motion filed by barrister Anyang Lewis, is Cameroon going to be the state of law? Is that the litmus test that the law will be the law? This is House of Commons. In the studio we have barrister Anyang Lewis, who have just joined us from this. He's coming from the City of Legendary Hospitality. With all the traffic, we want to apologize for his late coming on his behalf. Barrister Lewis, thanks for joining us.
Thank you, and I thank this television for having me here. Sorry for the late delay, and it's better late than never.
Yeah.
I'm here now.
Cameroon's president said that in 2004 in Boya it is better late than never during the reunification. You heard what I read from barrister Ebain Toko, looking at it still come in line with what barrister Anyang Lewis raised as far as the aptitude test is concerned, and barrister Toko raised a lot of provision. He started by raising the issue of law number 09/05 of 19 December 1990, and he went further in stating decree number 913052 of 4 July 1991, which is what he cited in his affidavit, and it stated that it's supposed to be organized yearly.
Yeah, obviously the law is clear on that, that bar exams are supposed to be organized yearly, but if you look at the past years, you'll see that it has always been a talk of war for bar exams to be organized by the ministry. Yeah, even though it is a collective effort, it's supposed to be a collective effort of the Bar Council and the Ministry of Justice. But most of the times, I think the Bar Council doesn't really push this matter so hard on the ministry. I don't know what they do, but I don't really see them so much pressing on the ministry yearly for them to respect this section of the law for bar exams to be organized yearly. You want to think that the government, some of the reasons they've cited not to organize bar exams are just, to me, not founded. They will argue the fact that they don't have money, they don't have enough funds to organize bar exam, which is, to me, is not really, it doesn't really hold grounds, because a ministry is supposed to budget the activities at the budgetary session in every November. And if they know that the law obliges them to organize bar exams every year, they're supposed to put this in their budgetary line and not stop giving excuses that they don't have funds to organize bar exams. To me, my reading is that the ministry doesn't really want more lawyers to be trained in Cameroon. And if you want to check every country, whether the nature of that kind of country, where it is a tyrannical state, you need to check the way that country treats or look at the legal profession. You check how they treat lawyers, you check how they treat the media men, or how they treat these two professions. Because the legal profession and the media are like a thorn in the flesh of every tyrannical government. And they will not really want more legal luminaries to be trained, so that they don't keep exposing their tyranny over the years. So you see, one of the reasons the government will hide behind not to launch bar exams is so much so that many Cameroonians should not be enlightened or should not get into the legal profession, because the legal luminaries are just like the watchdog of every society. They are just like the fight for the downtrodden. If you have a society where the law is not practiced, if the law is not seen to be practiced, the law is not respected by everybody. The law is supposed to be blind. It's not supposed to have eyes like in Cameroon. So it is really a pity that for many years today the bar exams have not been launched, and we are hoping that maybe come this December, as obliged by the law, the Ministry of Justice should launch this exam so that it will give opportunities for many young Cameroonians who have been languishing.
Okay.
Neighborhood something to do. Yeah.
Barrister Anyang Lewis, you are the author of this case. You filed a motion against your own boss. Can the law be the law, looking at the current reality of Cameroon?
Oh, let's make something very clear first. The Minister of Justice is not my boss.
Okay, you filed a motion against the Minister of Justice, keeper of the seal.
Of course.
Can the law be the law?
Of course, the law is supposed to be the law.
In this case?
You see, one thing, the law is on the text. Application is completely different. The law is very clear. Law number 91/305 of 4 July 1991 states that the Minister of Justice and the keeper of seals shall launch the bar exam every year in the month of December. The law is very clear, every year in the month of December. But you cannot imagine that for close to a decade now, the minister has not launched that exam. What is really happening? So it makes so many people to conclude that the government does not want, in fact, they don't want new lawyers. They don't want law graduates to access the profession. They think they can do as they wish in relation to the bar exam. The law is very clear. Why wouldn't they launch the bar exam? And one thing also, being a member of the bar, is that the Cameroon Bar Association also, they don't really take this matter seriously. You understand? Because ever since, I've not seen anything that the Bar Association has done formally to at least put pressure on the minister to organize that exam. We are not supposed to beg or clap for the minister to organize that exam. So we hope that, I hope that the motion and fight in court will come out positively, because the court has to take a very strong decision ordering the minister to organize that exam, because it's within the bounds of the law.
Now, so, if we go in context, why suing only the minister? Because the 1990 gives the prerogative for the minister as well as the bâtonnier who are in inter-allied. I may be wrong. But why suing only? Because it's like it's a collective effort. I will read that to you, but you wanted to react to that. You disagree.
In relation to that, the Minister of Justice and Keeper of the Seas has the yam and the knife. He is the only one to decide, not the bâtonnier. After he decides, he comes out with a degree commission on the head.
Now, you are saying that the law gives on the minister the ability to organize this bar exam. We have seen that from the 1990 law, it states that it first began in 1990 and 1991.
No, but I'm talking.
Okay, you are talking about from the.
Maybe you are showing it from senior barrister.
Yeah, I'm looking at what Barrister Toko said. I'm queuing from that to come to you, because it states that the minister, the bâtonnier, and the Minister of Justice work inter-allied. Now, if the Minister of Justice is not, or let's say, is too busy to organize the bar exam. Let's say it's too busy. For decades now, we have had 2 bâtonniers within this period. What has they been doing? What have they been doing?
That's why I said I've not seen, me with my own eyes, I've not seen anything that the bâtonnier or the Bar Association has done formally to cause the Minister of Justice to organize the bar exam. So I don't know why they give it a blind eye. Some school of thought, they say the senior lawyers in this country, they don't want new lawyers. That's what some people say, you see. Then you made mention of the fact that the Minister of Justice may be too busy. He cannot be too busy to do his job. You understand? If the law says that you shall do this every year in the month of December, you must do it. You must do it. It's not like they have to beg you or you are too busy. Then when he was talking, he made mention of the fact that they say they lack the money, the resources to organize the bar exam. That same law states that every year, the budget of the Ministry of Justice shall also include the budget to organize the bar exam. So money is not a problem. However, keeping aside that provision, even if they say there's no money, they organize the exam, people will pay. Even if it's 100,000 pounds, 200,000, people will pay. Cameroonians go outside, they spend a lot of money to attend law school. Just to pay small money to write the bar exam is not the problem. So people should not say money is the problem. How can money be the problem? So I think people should get that very clearly.
Okay. Now you talked about the aspect of he raised the issue of money, and you say the minister cannot be so busy. We have the Anglophone crisis. We have other laws that are supposed to put into place. We have other international missions that the minister is supposed to follow. Wouldn't it be fair to say the minister has been quite busy and maybe thought that the bâtonnier will actually take this as a forefront to meet with the Secretary General and see how these things can be done?
But at least he can delegate. He should delegate to the Secretary General. Please do this in my name. Just
I
like
think it is even the work of the Vice Prime Minister. No, the Vice Prime Minister in charge of the justice and keeper of the say. Yes. I think in the ministry it is his work to do that, and the minister is just supposed to visa.
Of just time. Yeah, just like what President Forba is doing with Ferdinand Gogo.
Yeah, it's not like he's a minister who's supposed to release a seat and do that. Yeah. It's the Vice Prime Minister. I think the post of the former the man was of late Amadou Ali. He was the one.
I want us to go to the affidavit. Yes. I want us to look at, first of all, based on you cited decree number 91/305. 3052 of July, of 4 July 1991, and which you said he violated section 2 of that, and that section 2, which you say the minister violated. Let's first take Article 1. Article 1 states that the aptitude entrance into the pupillage shall be written in the month of December each year. Yes. So that point first, let's start with that first point. So you are saying that this is violated grossly.
Of course. Of course, the minister has for so many years, close to a decade, close to 10 years now, violated that provision. As the forerunner of the law, the vanguard, the #1 lawman in the country is the Minister of Justice. But why would he apply that law? What is holding him back? What is the secret agenda they have concerning this law? They should tell us, we should know. It's very clear. The wordings of that section of the law are very clear. The minister should launch the bar exam.
Yeah, it's
every year in the month of December.
Yes.
And thank God I filed my motion in the month of November. December, from next week will be in December. We are hoping that the minister should just do the right thing. Based on my motion, at least he should examine himself and see that never is better to be late than never. December is the right time, and from next week will be in December.
Article 2 of that same provision you now cited that he violated says, an order from the Minister of Justice shall fix the condition of organization, date, place, and exams, as well as a list of candidates. Yes. Article 13 of that same decree states that the minister, that's why I'm coming now, which I guess the issue, which you said, which you gave an answer, and I want you also to look at it again, which the Minister of Justice, Article 13 of that 1991 for July, the Minister of Justice, keeper of the seals, and the President of the Bar Council, bâtonnier, are, as they are concerned, charged with the application of the present decree. Charged with the application of, is it not inter-ally? Is it only the Minister of Justice?
With the application of that decree, based on their role at the various levels. Who takes the first step? So who kicks the ball first? So
why didn't you sue the bâtonnier for failing on to put it for neglect of his duty?
Because if I sued the bâtonnier wouldn't have done anything. Imagine I sued by the bâtonnier, what would he do? The current bâtonnier now, Senior Barrister Eric, he wants to launch the bar exam. If he had the power, he would have launched the bar exam since immediately took over. But he knows that he does not have that power.
Well, you say he does not have power, but the law in 13 state 13, the Minister of Justice, keeper of the seal, and the President of the Bar Council, bâtonnier, are, as they are, concerned, charged with the application of the present text. 13 supra read, invest the Minister of Justice and the President of the Bar with the responsibility of ensuring inter alia that the bar entrance examination is conducted every year in the month of December.
That's very true.
And when you say the bar president is willing, but we are not seeing the effort based on
his only role is a subordinated role. At Section 1 states that the minister should organize the exam every year in the month of December. Section 2 says that the minister shall come out with a decree inside that decree, the minister shall create a commission to organize the exam and everything, to supervise, do everything. And part of the key, one of the key stakeholders of that commission is the bâtonnier. That's where he starts playing his role in relation to the bar exam. It's just supervision and some kind of technical issues. But no, he does not have the power to organize the bar exam. The bâtonnier does not have that power to organize the bar exam. It's very clear. That law is very clear. Yes, below that law now, they say that the Minister of Justice and the bâtonnier, they shall ensure the application of that law. They have their levels in which they intervene. The minister has a key role. He intervenes, he reacts as the first person, the number one player. If he does not organize that law, nothing can happen. The bâtonnier cannot do anything. It's after he must have organized the law, constituted the commission. It's from there now that the bâtonnier can start playing his role. So I think that provision is very clear. The bâtonnier has nothing to do.
Okay, I'll be coming back to you. Nick, I don't know, this is a lawyer playing us with the legal jargons, but I want us to look at this now from a civil society perspective. Let's say the law mandates the minister, that the minister come as it is in the law, that each year the minister shall call for the bar exam in December, that the budget shall be included each year into the Ministry of Justice, and also sub 13, which says that the minister shall work in collaboration, that the Minister of Justice and the bâtonnier shall be in charge of ensuring that that decree is respected. But for decades now, we have had two bâtonniers. As far as that is concerned, the bar has not been called. Is it not part of the negligence too from the bâtonniers themselves? Because we see from the political perspective how political parties push for motion, they push for pressure. Sometimes they call press conference, sometimes they go on a peaceful protest, sometimes they write a letter, sometimes they write an official memo communicating that we intend to do this, but it's not being respected. But with the bar, it's kind of like, maybe, I don't know.
Yeah, it would seem to me that the bâtonniers themselves maybe don't want more competitors to come into the field of the law. Because to me, if they really wanted new lawyers to be there and they are really serious about it, they will know how to pressure the ministry to launch this exam. But if you study from the past, more than 20 years behind, you see that this has been a talk of war between the bâtonniers and the ministry. Sometimes the ministry, they will always stay 7 years, 10 years before, under pressure before they will launch the bar exam. But I think the Bar Council should be more proactive on this. The Bar Council should maybe be more firm that every year they make sure the minister launches this exam. To me, the bâtonniers are supposed to pressure the minister like they do in other cases. You see, for example, before the advent of the Anglophone crisis, the lawyers were the ones championing that. Why can they not use this same spirit to pressure the ministry or the minister to launch the bar exams yearly? They can do this if they have the interest of the aspiring lawyers at heart. The bâtonniers can do this. There are many ways they can do this. They can maybe refuse to go to court. That's another aspect, to refuse to go to court to show their discontent with the minister. There are many other things they can do. So to me, if they really want the minister to launch this exam every year, we see them as playing an upper hand. They can play a better role to pressure the minister to launch this exam. Because over the year, I've not really seen the action of the bâtonniers. Apart from maybe just some kind of statements they made from time to time, you've not really seen their front row, or a major role they play, or a major force they build in order to pressure the minister to launch this exam every year. It means that there are certain hidden
There's
things.
a conspiracy somewhere.
Yeah, there are certain hidden things that are not telling us.
Okay, barrister, let me come to you. He raised an issue, and that was part of what I wanted to ask you. When the OHADA law was not translated,
Good.
the lawyers were firm on that the OHADA law, when the issue of the respect of that should be translated, when the issue of the common law also was raised, the respect of the common law and the redistribution of magistrate, we saw how the lawyers stood firm. And that catapulted us to a protest in Moya by the Fako lawyers, Meme, and also we saw that Mbamenda, Bob Harmony, and the rest. Now, we also saw how lawyers have demonstrated unity, firmness, when a lawyer was arrested in Boya, and when they say a colleague of theirs was poorly treated. We saw how you guys went there. Now, this issue, where we have thousands of Cameroonians languishing in their houses with dreams of becoming lawyers, are dying every day. Some have died. If you count close to 14 years now, we've not had this bar. Close to where we moved to 14. Imagine that somebody who graduated 3 years before the last bar was organized, at this current time that we actually be about 14 years. Exactly. So if you look at all this context, but the lawyers are lukewarm about it. Is it because some of them are eating fat from the silence of not organizing the bar? Because are they eating fat for me?
You know, some senior lawyers will say the more lawyers into the system, it reduces their level of clients, number of clients, you see, which is very true. And so many senior lawyers are of the opinion that the exam should not be organized regularly, which is very bad and frustrating. Because they, senior lawyers, they have the money to send their children to law schools abroad, anywhere in the world. But what about the common Cameroonian? They don't even have money to attend university. We don't have money to go to law school. But every year, we have law graduates from law faculties. They cannot access the profession because the Minister of Justice has refused. I must use that word, he has refused.
When you say the Minister of Justice has refused, are you by chance charging the Minister of Justice for violating the law?
Of course, he has violated the law. There is no, we should not go around it. He has violated the law for close to a decade now, close to 10 years. He has not launched the bar.
Don't you think that there could be a reason why the minister has not
done this?
What kind of
reason?
Maybe he's too busy.
What kind of reason that the reason should be above the law?
Maybe he's too busy. Maybe he has not looked at this.
Human beings are being regulated by the law. If the law says that you should do this, you should do it. Then coming now on the side of the bar, like I've been saying, ever since I've been growing up, I've not seen any concrete evidence to show that the Cameroon Bar Association or any bâtonnier has ever done anything concrete to at least put pressure on the Minister of Justice to organize the bar exam. Like you see, I just came in now as a young lawyer. I've made a very concrete move that everybody can see. At least it's direct evidence.
It's
everybody
tangible.
can see that, no, this man is trying to do something for the Minister of Justice to do his job. At least at the level of the bar council members can sit, take a resolution on that. That will pressure the minister. They can go on air. They can even protest and say, we will not go to court for a number of...
protest again?
No, you see, we can do things peacefully. We can.
You remember what the lawyers, we are having this Cameroon crisis because of the lawyers.
Insofar as
we don't want to hear protest again.
Insofar as there's injustice, we always have this kind of things.
No.
No, you see, things can be done peacefully. We just sit at home, we say no court for some time. You see that kind of thing. Or at least the bâtonnier, as the head of all lawyers in the country, can even write a letter to the minister.
Yeah, because I was about asking that, barrister.
Do something for us to see
that we have not seen a communique.
Yeah, no
from the
memorandum, nothing.
We have not, from the last bâtonnier to this current bâtonnier, we have not seen it. And we are counting 14 years. I'm saying that if a law graduate, a student graduated 3 years that the Bar Council was launched, just 3 years.
Yes.
It means that if the Bar Council was launched, let's say in 2020, and a student graduated in 2021, if you calculate from there, come now till now, it's about 14 years. No, moving to 15 years. So for 15 years, aspirants are in their houses.
The last time the bar exam was organized, 2014. Yes, of course. So you cannot imagine now, those who were dreaming, those who left university around that period, after that period, right up to now, who are dreaming to access the profession.
And those who failed the exam thinking that they will rewrite.
No, but some they launched the other one, so it absorbed those who failed.
Now, barrister, many are saying that senior lawyers are benefiting from this. That's why they have not supported your motion, because they said one would have expected to see that we coming up with this motion that has been appreciated by a lot of university students who have taken this on social media and stating that thank you for fighting for us, thank you for standing tall to us. And many were expecting that many senior lawyers like Barrister Tako, the Fako Lawyers Association President, Barrister Bala, and all those will really be behind you and say, yes, what this young man is saying is true, because you are adding your voice to what Barrister Ntoko said in 2016 from his publication, 2006 from his publication. But they have not seen it, and they say that it means that they are benefiting for not launching the bar, because if you have to go for in-chambers training, you have to pay, you have to give some gigs, you have to bring gigs, you have to write, you have to assist these lawyers to write their project, you have to assist them to come take their fight to court, and that if this bar is launched, they will not have people to take their fights to court. If a law school comes, they will not have people to be taking their fights to court. They will not have to pay their secretaries. Is that true?
To an extent, that's somehow true. People have their reasons, you see. But I cannot really speak for the senior.
You have been watching what is on the ground. Is that not what is on the ground? You own the chambers. Is that not what is on the ground?
I cannot really speak for senior lawyers, but all I can say is that senior lawyers too in this country, no one has ever taken a concrete step to like pressure the bar, pressure the Minister of Justice for him to organize the exam. Though they say they benefit, it's true. Like, because with the current system that we have now, when you graduate from the university, you become a postulant, or postulant, like they call it in the French section, then aspirant, like they call it in the English section. You are in a law firm, they don't pay you, you just work, you carry the briefcase of the principal, you do some kind of thing. In fact, you are like his boy. But that's not really good. It's not really good for development, because it's like you are an apprentice for a very long time. How can you be a postulant or aspirant for more than 7 years, or an apprentice in any trade for more than 7 years, 10 years? Is that proper? But if you leave university, you graduate as a law student, the law says every year they should launch the exam.
Every December.
Every December. You wait December, they organize the exam. You write, you pass, at least you have that title of a lawyer, you can be independent. You can be independent, you'll be making a lot of money. Honestly, the legal profession is a very lucrative profession. But without that, it becomes very frustrating to those who aspire to become lawyers in the country. And mind you, we're in Africa, the level of poverty is alarming. We have more poor people in the country than rich people. So majority of students cannot access the law schools. At least I was fortunate, and some lawyers, our parents had money to send us to law school. But what about the millions of Cameroonians, or let me say thousands, who cannot access the law school? You see, you find them frustrated in the neighborhood. In fact, their lives are miserable. I have so many classmates like that. But I cannot give a blind eye. If the bar, they cannot at least pressure the Minister of Justice. If the minister cannot do his job, I have no choice as a lawyer to file a court action. As a lawyer, we like court, so we like court cases and all those things.
You wanted to add? Nick, okay, you want to say something? Well, I just posed my question. You listen to it. There is this school of thought that says that lawyers, as like him, because he owns the chambers, that
I own a law firm.
A law firm.
Chambers is a primitive.
Yeah, he owns a law firm. that they are the ones making this bar exam not to be launched, because they want to be using these aspirants to carry their bags to court, to send them to transfer credit, with the hope that one day they will launch a bar, and that when you launch a bar, they will have to pay also in their chambers registration dues and all these dues, because you must register through a chambers. I'll be coming to you must register through a chambers, through a law firm, not like an independent person. You must register through a law firm. You have been talking with lawyers. Is this true? Is this true? The assertion that they use people as they want to use them as their land boy, to put it that way, more because they don't pay them.
Yeah, it's true to an extent, but if it poses no problem if the bar exams launch every year. You always have a pupillage under you, because I think when you pass the bar exam, you're supposed to go under pupil. I think it's 2 years.
Yes,
Cameroon.
2 years. 2 years
in Cameroon before you are called to the bar. If you take, for example, if they launch exams every year, if you have your law firm, you always be having people who will be subscribing under you. So saying that you will not be having people, it is of no advantage to be having people under you for 5, 6, 7 years, and it makes no sense. That holding people's destiny like that. You don't know whether they will write the bar exam and pass after 7 years of being under you, and so on. So it is very, very frustrating. I think the bar council need to do much. They need to pressure. If they cannot pressure the minister to launch bar exams every year, they should pressure him to, they should pressure him to open a law school.
Okay.
A law school will be of great help also. I think these are the work of I think the bureau of the Bar Council just came in some months ago. It should be some few months that this new bureau came in. Their main mission or their mission should be to see that a law school is created in Cameroon. Because if you imagine the millions that people spend out of Cameroon to go to law school, it is very frustrating.
Messages. Happy Sunday to you guys in the studio. I think that Barrister Anyang's case is very good, but if we look at the reality, I'm not sure that justice will be served. This is coming from Mbula and Boya. This one he says, happy Sunday to you guys in the studio. The barrister is just throwing water on the deck's back because who owns the law? The keeper of seal and minister of justice. So he cannot win this case. Even if he's correct, but he will not be able to win the case. This is coming from Sophia in Douala. Good afternoon to you all in the studio. I think that the legal mind has filed his motion. If that would be in America, then we can say he can have a case. But in Cameroon, I fear he may even be arrested and charged for destabilization. Thank you very much. And this other one says, happy Sunday to you guys in the studio. I like your program, but my question is, the Action Gote, thank you very much for your participation. This one really says, hi, I am writing from Boya. I wish to find out if the minister himself will be present or will send someone, because he should be present to listen to how he is not respecting the text after it has been cited on the affidavit. We will be taking on your messages. What is your take on this issue? Therefore, Barrister Anyang, many are also of the opinion that the affidavit is more on the law than fact. How true is that? Because I spoke with some lawyers about this and I asked the question. I was in Boya yesterday and said, but this motion has been filed by Barrister Anyang. I expected you senior lawyers to back this motion, because we have talked about this. I'm sure last year I brought former batonnier, Barrister Itabisong Jr., and I asked the same question about the organization of the bar. And he cited a lot of issues within the bar itself, that the bar itself is a speed breaks to the organization of this bar exam. And I asked the question.
Barrister Itabisong said that himself.
That there are some members within the bar. So now I'm asking you this. What's the problem that many have not come to you to assist or to join their voice with you?
Yeah, I decided to file my action independently. I did not consult any lawyer or senior lawyer whatsoever. I did not consult anybody. I decided to file my action freely, out of my own volition, you see. So now, immediately when I filed the action, eventually it went on social media, it went online, people started criticizing, some supported, senior lawyers were very quick to react in relation to that affidavit. We know, as per the relevant provisions of the ordinance, the evidence ordinance, the affidavit is not supposed to contain law. But you see, we are all lawyers. We know how to go around issues. My case is before the court. At least, you know, now the modern judicial trend is that technicality will not vitiate the interest of justice. And if the judge now takes my affidavit, he sees that maybe there are some paragraphs that are not supposed to be there, he will not reject my application because I included law on the affidavit. You have to shift that in, then consider the things that are supposed to be there. So that argument has no place.
Yes, that is more fact. That is not backed by fact. It's based more on the law.
Yeah, they say it's based more on the law. But however, there are facts there. They cannot deny that there are no facts there in the affidavit. As lawyers also, if a lawyer files his action, don't over criticize too much, because you don't know the grounding of that lawyer.
And I asked a question to that with some of these lawyers that, okay, if you say there were more of the law than facts, why don't you file the motion for facts and back it?
That's the problem too.
And they couldn't answer the question. And I asked, who is pushing you now to file this motion?
Pushing me?
Yes.
No, nobody.
Because you seem to be alone.
I'm alone. Nobody's pushing me. Nobody is supporting me. Nobody has given me money. If anybody comes out and says that he has given money, then that person has serious problems with me. They want to file another lawsuit against that person, because nobody has given me frank. It should be very clear, because some people will see it. I've been hearing comments left and right. Some people say, oh, maybe he has collected money. You know how Cameroonians are. But well, people always talk no matter what you are doing. People always criticize. People have insulted me saying I'm looking for cheap popularity. But I don't blame them. I'm not a dictator. Only dictators don't like that people should insult them. If there is anything that you are doing, some people will be for, against, and in the middle. And I welcome those who insult me. It's part of the democratic.
Let's stay within the context of the affidavit which you filed, and which let me go to the affidavit itself, which you stated clearly. Where is it? Let me read it for the sake of our audience.
Maybe you can list the paragraph.
Yeah, I will list the paragraph. I will list the paragraph so that the audience can get what you're saying in context on the affidavit. Because you said,
paragraph.
First paragraph, you said, an order of Magdemus of the minister, order of Magdemus for the Minister of Justice to immediately, urgent and without delay, organize the aptitude test into pupillage at the Cameroon Bar Association as regulated strictly by Section 1 and Section 2 of Decree number 91/305 of July 1991, organizing the aptitude test and the pupillage at the Bar Association. Point 2, an order of Magdemus for the Minister of Justice to always organize the aptitude test into pupillage at the Bar Association. Every year in the month of December, as regulated strictly by Section 1 and 2 Section 2 of the Decree 91/305 of July 1991, organizing the bar aptitude exam, bar exam. Section 3, question 3, the third point you said, and for any further orders that this honorable court may deem fit and proper to make in the circumstances of this case. When you talked about any order for any further orders that the honorable court may deem it fit, what do you mean by that?
You know, judicial practice is that whenever you file motion, you give an extra discretion to the judge. Maybe the judge may see that he needs to issue another order. So that provision, the number 3, gives the judge the discretion to issue any other order that he or she deems it necessary, but based on this case. You see, but my main prayer is number 1 and 2 of the motion paper. That's it. For any other further order that the honorable court deems it necessary, that's left for the judge to decide.
And you move down to the affidavit support for a motion on notice. On point 10, you say that that this time for this section, this serious social injustice to be corrected and brought to an end, this honorable court, the Fako High Court, do you see them throwing away this case?
No, they cannot.
Based on some of the languages being used by some of your lawyers in Boya, whom I spoke with, and who could not answer some questions I raised, that it is more of law than fact. They expect that you will say that this number of students are out, this number of students.
But well, it's very clear that I'm happy because nobody is challenging the provisions of that law, which makes it mandatory for the Minister of Justice to organize the bar exam every year. They keep criticizing my affidavit, and we know there are always critics in society and detractors also. We welcome their opinions too. The court cannot throw away my case because of some 1 or 2 minimal irregularities. You understand? The case will go through. Even though so many people are saying that, well, it's the Minister of Justice, they cannot do anything against him. Let's leave it for the courts to decide.
But that's not true, because the Minister of Territorial Administration has always been firm that Cameroon is a state of law.
Yeah, that's what all of them they preach. Even the minister is the number 1.
So you are using this as a litmus test to test that statement.
The Minister of Justice should do his job. That's all I can say. He should do his job and save so many Cameroonians who are wallowing in abject poverty.
This one, right, Elad from Limbe says, good day to you all there in the studio, Mr. Tah Mai Javis. I want to thank you very much for these beautiful programs that you always think of coming up with to redress some of the sectors for this country that are broken down, either ignorance or by wickedness. We thank you people in the House of Commons. Now I want to say to Barrister Lewis is that we like his courage and the bold step he has just taken to help future lawyers in this country. I am Elite, writing from Victoria. Happy Sunday to you, Sarah Okoye, watching in Limbe. Big picture. Happy Sunday to you too, and I hope that the Sunday is moving on well with the graduation, which is around the corner at the City of St.